In Frisco, Texas, every house on the block looks like the last one. Same roofline, same mailbox height, same approved shades of beige. And on one door, a laminated notice, a fine for a trash bin left visible from the street. There are 358,000 homeowners associations in the United States right now. Roughly 74 million Americans live under one. In the United Kingdom, Germany, Japan, mandatory single-family HOAs governed by private boards with the power to fine, lien, and foreclose simply do not exist at the scale they do in the US. In Texas, a woman named Robin Cull lost her home, a home with $60,000 in equity, at an auction for $3,500. Her debt to her HOA, $268. This is not a story about nosy neighbors or paint color disputes. It is a story about where this system came from and who decided it could never be undone. There are more homeowners associations in the United States today than there are cities, towns, and villages combined. That number, 358,000, did not emerge from generations of organic neighborhood preference. In 1964, there were approximately 500 HOAs in the entire country. By 1980, 36,000, but by 2023, 358,000. That is not a trend. That is a mechanism. In the Sun Belt, it is nearly impossible to buy a newly built home outside one. The National Association of Realtors has found that more than 80% of new homes built in Sun Belt metros since 2000 sit inside an HOA. In many of those markets, if you want a new home, you are getting an HOA, whether you asked for it or not. And these are not toothless bodies. An HOA can fine you, lien your property, foreclose on your home, restrict whether you can rent to a tenant, dictate your paint color, your holiday decorations, your visible trash schedule. That is more coercive authority over your property than most landlords legally hold over their tenants. Except you own the home. Countries with comparable wealth and comparable suburbs do not have this. Germany's shared ownership law, the Wohnungseigentumsgesetz, governs apartment buildings. Japan's Building Units Ownership Act does the same. Neither creates a private governing board with lien and foreclosure power over a detached single-family home and its lawn. That combination, at this scale, is almost exclusively American. Most buyers find out they are entering an HOA in the final days before closing, after inspection, after financing, after the decision has been made. CC&Rs, the legal documents that govern the HOA, are often disclosed too late to negotiate. The buyer can walk away and lose their earnest money, or sign and inherit a private government they never elected. But that still does not explain how 74 million Americans ended up governed by something nobody ever publicly voted to create. The legal mechanism is called a CC&R, a covenant, condition, and restriction. It is not a contract between you and your neighbors. It is an attachment to the deed of your land. It runs with the land. When you buy the house, you buy the CC&R. When you sell it, the next owner inherits the CC&R. It survives refinancing. It survives death. To remove it requires a supermajority of all owners in the development, and in many cases, the original developer's consent. The common assumption is that HOAs exist for the same reason condo associations do. Shared walls require shared rules. That logic makes sense for a high-rise. It does not explain why a detached single-family home on its own plot of land in suburban Texas needs a private board to govern the color of its shutters. The more uncomfortable fact is this: the HOA was not created by the residents who live inside it. It was created by the developer before a single resident moved in. The developer writes the CC&Rs. The developer establishes the board. The developer sets the rules. Then the developer sells the homes and leaves, and the residents inherit the governance structure without having negotiated a single line of it. In the fastest growing metros in the country, choice has become largely nominal. In Frisco, Texas, one of the fastest growing cities in America, the vast majority of housing stock is HOA governed. You cannot opt out by choosing a different subdivision. There is no different subdivision. The people who designed this template did not live in these neighborhoods, and the institution that made it standard was not a homeowners group at all. Robin Cull lived in Baytown, Texas. She had owned her home for years. When personal hardship made it difficult to keep up with payments, she fell behind on her HOA dues. The amount owed was $268. The HOA did not negotiate. It did not offer a payment plan. It initiated foreclosure. Under Texas law at the time, an HOA could foreclose on a home without a court judgment for non-assessment debts. The HOA held lien priority. That means in the legal hierarchy of who gets paid when a house is sold under duress, the HOA stood at or near the front of the line, ahead of Cull's own equity position in a forced sale. Her home went to auction. It sold for $3,500. She had approximately $60,000 in equity. That equity did not go to her. The Dallas Morning News documented her case as part of its 2012 investigative series, The Price of Belonging, which found dozens of similar cases across Texas. Homeowners losing properties worth tens of thousands of dollars over debts measured in hundreds. Texas was not an outlier in the direction of abuse. It was an outlier in the degree of permissiveness. Nevada, Colorado, and Florida had similar HOA lien priority structures. The same pattern played out in each. This was not a rogue HOA acting outside the law. That is the part that matters. The HOA was doing exactly what the legal structure permitted, and in some respects, exactly what it was designed to enable. The question has never been whether this was legal. It was. The question is, who designed the system that made it legal and when? In 1934, Congress passed the National Housing Act. It created the Federal Housing Administration. The FHA did not build homes. It insured mortgages, and in doing so, it set the terms for what kind of development qualified for federal backing. Banks followed those terms. Developers built to those terms. The American suburb, in many ways, was shaped by what the FHA was willing to approve. Through the 1940s and into the 1960s, the FHA issued a series of land planning bulletins. These documents required that new subdivisions include deed restrictions designed to protect and maintain property values. The logic was financial. The FHA was backing long-term mortgages, and it wanted assurance that the neighborhoods it was funding would hold their value. Deed restrictions, binding rules attached to land, were the mechanism. In 1964, the Urban Land Institute published the Homes Association Handbook. It was an explicit instruction manual for developers, how to create a homeowners association, how to write CC&Rs, how to establish a private governing board. It was written in direct coordination with FHA approval standards. The message to developers was not subtle. Subdivisions that included HOAs to manage common areas were more likely to receive FHA mortgage insurance approval. Federal mortgage access, the lifeblood of the post-war housing market, was attached to this structure. Here is the mechanism no one explains at closing. HOAs allowed developers to build private roads, private parks, private drainage systems, and then permanently transfer the cost of maintaining all of it to the residents. That maintenance cost did not appear in the sale price. It appeared every month in the form of HOA dues. Infrastructure became a hidden recurring fee. The developer captured the upside and handed the residents the obligation. Evan McKenzie, a political scientist at the University of Illinois at Chicago, put it plainly in his 1994 book, Privatopia. The private residential community is government's silent partner in the privatization of infrastructure. The American suburbs' private government was not a cultural accident. It was a deliberate policy product designed by the mortgage industry, formalized by the federal government, and sold to buyers as neighborhood amenity. Once that template existed, it had a constituency, and that constituency was not going to dismantle it. By 1973, the HOA industry had organized. The Community Associations Institute, CAI, was founded that year as the national trade group for HOAs and the companies that manage them. CAI trains HOA board members, publishes operational standards, and lobbies state legislatures across the country. It has consistently opposed legislation that would limit HOA foreclosure authority. It has consistently opposed requirements that would make it easier for homeowners to amend or exit CC&Rs. For 5 decades, it has worked to keep the legal structure that produces HOA revenue intact. Evan McKenzie documented the consequences in detail, first in Privatopia in 1994, then in Beyond Privatopia, published by George Washington University Press in 2011. Foreclosure abuse, selective enforcement, financial mismanagement, boards operating without transparency or accountability. These were not emerging problems when McKenzie wrote his second book. They were documented patterns that had existed for decades without producing a federal response. HUD, the Department of Housing and Urban Development, which absorbed many of the FHA's functions, never revisited the 1964 HOA incentive structure, never unwound it, never subjected it to congressional review on the question of whether private governing boards with foreclosure power should remain a condition of mortgage market access. The structure that FHA and ULI built in 1964 remained essentially intact into the 2020s, despite everything that had accumulated against it. The constitutional protection is deliberate and durable. Because HOAs are private entities, not governments, First Amendment and equal protection claims that restrained state action do not straightforwardly apply to them. An HOA can enforce rules that a city council legally could not. It can act in ways a government agency would be prohibited from acting. And because it is framed as a private contract freely entered by the buyer, the courts have largely deferred to that framing. The result? A governance structure affecting 74 million Americans. No federal oversight. No elected accountability. Active lobbying presence at every state capital. And for most of those 74 million people, no practical exit. Reform did come, eventually. The Dallas Morning News series in 2012 drew national attention to the pattern of HOA foreclosures in Texas. Over the following decade, multiple states moved to constrain the most extreme HOA powers. Nevada amended NRS 116, its HOA statute, to limit lien priority and require additional procedural steps before foreclosure. Colorado and Florida passed similar restrictions. In 2021, Texas passed SB 1919, which prohibited HOAs from foreclosing on a home solely for non-payment of fines, as opposed to base assessment dues. It was one of the stronger state-level HOA reforms passed anywhere in the country, and then something happened that the reform movement had not fully anticipated. HOAs that lost the foreclosure threat as their primary enforcement tool did not become more lenient. They shifted to a different mechanism: legal fee escalation. A homeowner who falls behind on $400 in dues can now find themselves facing a court judgment of $4,000 or more because attorney fees and collection costs stack on top of the original debt through HOA management company referral pipelines. The debt grows faster than the homeowner can respond. First, Service Residential, Associa. These are among the largest private HOA management companies in North America, operating across tens of thousands of communities. Their business models depend in part on collections referrals, sending delinquent accounts to HOA-affiliated law firms, generating fee revenue in the process. The reform that limited foreclosure did not touch this structure. In some ways, it intensified it, because legal fee escalation became the dominant remaining lever. The homeowners most exposed to this model are the ones least equipped to navigate it. Low-income residents, elderly homeowners, people in older affordable communities that happen to be HOA governed. They are not in the luxury subdivisions with well-funded reserves and professional management. They are in the communities where every dollar matters and where the fee spiral can be fastest. The fix removed one coercive tool, and the structure underneath it handed them another. Go back to that door in Frisco, Texas. The laminated notice. The fine for a trash bin left out past the approved hour. It looked, at first, like an illustration of suburban absurdity. The pettiness of neighbors policing neighbors. It is not that. That notice is the visible surface of a privatized infrastructure financing system assembled in Washington in 1964. The FHA needed development to qualify for federal mortgage backing. The ULI gave developers the manual to build HOAs. The developers built the roads, the parks, the sewers, and handed the ongoing costs to residents as a permanent monthly obligation. The CAI organized the industry that would manage those obligations for profit. The states wrote the lien laws that gave that industry teeth. And then, when the teeth were pulled, the industry found a different bite. The reason no other wealthy country has this at scale is not cultural. Other wealthy democracies did not privatize subdivision infrastructure. Roads, parks, and sewers in new developments remained municipal responsibilities. Maintenance costs remained public. There was no financial incentive for a developer to create a private governing board because the infrastructure was never theirs to transfer. America cannot easily exit this now because 74 million people's home values are partially secured by it. The CC&Rs that seem like petty control mechanisms are also, simultaneously, the legal instruments that protect shared property maintenance. The parking rules, the paint standards, the trash schedules, they are bound up with property values in ways that make unwinding the whole structure genuinely disruptive to the people already inside it. The HOA was never really about your lawn. It was about who pays for the street in front of it and who gets to govern you while you are.